but I do believe that the bond should reflect the charges. I think that Ypsilanti has a serious issue, which you probably know a lot more intimately than I do with respect to what's going on. But, like...
I don't know what you want me to say.
Preparing it is a lot of stuff.
But that's not going to happen. Ypsilanti is a wonderful city with wonderful people.
It's a wonderful city, but there's a problem.
Every place has problems.
Right.
I don't think Ipsy is any different than any place else, but I'll let you go ahead. But you start attacking my home, we're going to have a problem.
I'm not trying to...
Specific waiver, and I'll put it on the record. It's my understanding that Mr. Sweat will be right through the examination and it would be on the how I show the charges, and hopefully it's the same way the court should. 2, weapon. Count 3, weapon possession by prohibited person or felony possession, and then count 5, 1 count for felony firearm. Those 3 counts only. Count 1, discharge from a vehicle causing death. Count 4, open murder, and count 6 and 7, both felony firearms, would be dismissed on this waiver.
And count 1, 4, 6, and 7.
Yes, 6 and 7.
Okay.
So effectively, Mr. Sweat is waiving up on 3 weapons-related charges for further proceedings in circuit court.
3 and look. Did we was there an amendment at some point?
So looking at the amended,
I gotta find it, only because on the original, I have the 3 counts, and there had to be an amended because the homicide comes 4. There it is. All right.
so on the amended, it would be 2, carrying a concealed weapon, count 3, possession by prohibited person, and count 5, felony firearm.
Yes. Well, there were count 5 and 6 are felony firearm.
It would be actually the count 7 felony firearm, because it would be the felony firearm connected with the possession by a prohibited person.
Got it. Okay. So, got it. Let me just redo this.
And of course, Your Honor, I will make sure that an amended information is filed in circuit court.
Correct.
To accurately reflect this.
Okay, so what I have is that he's going to waive up on counts 2, 3, 7, and that counts 1, 4, 5, and 6 would be dismissed.
Correct, Your Honor.
All right. Barnwell, is that your understanding?
Yes, Judge.
All right. Mr. Sweat, you understand that, sir?
Yes, sir.
And you're waiving your right to a preliminary examination on those charges?
Yes, sir.
All right. And you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes, sir.
You understand you'll not have that hearing, you'll proceed to circuit court
Yes,
on
sir.
these charges. All right. People also waive their right.
Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on counts 2, 3, and 7. Counts 1, 4, 5, and 6 are dismissed. As to the circuit court arraignment, Ms. Barnwell,
Your Honor, we waive a reading of the information and stand mute.
made way for reading, standing mute to charges 2, 3, and 7. Court will enter a not guilty plea. Pre-trial will be set for
February 18th at 1:30 with Judge Conlon.
February 18th, 2026, 1:30, Judge Conlon.
Your Honor, I wanted to address bond.
Yes.
My client's been incarcerated for 7 months now, or almost 7 months. The prosecutor is, this is a dismissal of the homicide charges in good faith. I'm pretty sure.
All right, guys, buckle up, because this hearing opens with something serious. The court lays out a waiver deal where the biggest charges, murder and homicide, are straight up dismissed. That alone tells you this case didn't age the way the prosecution expected. The judge carefully walks through each count, making sure everyone's on the same page. This is one of those moments where silence in the room says more than words. The defendant isn't celebrating, he's surviving.
That the prosecutor has looked at the evidence, and when I spoke to him, that was conveyed to me. So, Judge, I'm respectfully asking that this court grant my client a bond where, even with a tether, Judge. My client, before being arrested here, did matriculate at community college, which was at Washtenaw? At Washtenaw Community College.
Response.
Thank you, Your Honor. I will, regarding the defendant's criminal history, there's a 2016 carrying a concealed weapon. It was under HIDA, a 2025 RNO, a 2023 felony destruction of police or fire property, a 2023 domestic violence, and a 2023 home invasion second degree are what I show as prior criminal convictions. Everything I do is in good faith, but I don't disagree with Ms. Barnwell. This is not a plea agreement. This is not in exchange for something. This is a discussion with Ms. Barnwell, discussion with the police, and a careful consideration of the facts of this case. This is not putting forth a case to this court at preliminary examination on something that we cannot prove. So that is why we've elected to allow this waiver on the charges before the court here today. I would be remiss in acknowledging that the defendant was positioned in a vehicle where the driver of that vehicle, the co-defendant Devontae Owens, shot and killed Dejan Ryan on the date that this murder took place. And prior to that taking place, Mr. Sweat was engaged in a heated altercation with Dejan Ryan's in a McDonald's around the corner, basically at Ecorse in Michigan. And then that led to the shooting that eventually took place by the co-defendant. Obviously, if Mr. Sweat was involved and actually shot, we would be in a different situation. We're not. But I think that it's important to have context as to why we have these associated weapon charges. I still, despite the fact that we now only have some five felonies, have concerns for the safety of the community, given the circumstances around these possession of firearm charges. I would request, bond's probably denied at this point, right?
Well, what do you show? Because I show as bonded, but that may have been from the original charges. I show as bond at 1 million cash surety.
Thank you.
I believe that is still correct.
That is so correct. His current bond is, as originally said, at 1 million cash surety.
I did miss one important conviction in 2017. He was convicted of the possession of a firearm by the U.S. Attorney's Office.
So he did federal prison time. I'm not sure.
I would request, I'm not going to ask for $1 million bond charges before the defendants, but I would ask for a $50,000 cash or surety bond with a tether if he posts that bond.
Anything else, Ms. McCall?
Yeah, no, I'd respectfully ask for much lower. You know, my client is, I don't want to litigate the case in front of this court. I really don't want to litigate it in front of this court, but everybody here is not clean, including the complaining witness. So it's like a dangerous situation. And I think my client's life is in danger too. I really do. I've been around, we have argued unsuccessfully, and then somebody dies, you know? So, Your Honor, I will still stick to my argument that the prosecutor had a lot of months to contemplate, to look up to, and do all of this stuff. We had lots of stuff that we went through in terms of evidence with respect to my client. We took opportunity here today. But I do believe that the bond should reflect the charges. I think that Ypsilanti has a serious issue, which you...
Now we hit the bond battle. Defense steps up saying 7 months behind bars is enough and reminds the court the homicide charge is gone for a reason. Prosecutor fires back hard, listing gun charges, violence, and prior convictions, including federal time. The judge listens without reacting, eyes on the record. Then the decision drops. Bond slashed from $1 million to $100,000 cash with GPS tether. Not freedom, but a crock in the door.
Probably know a lot more intimately than I do with respect to what's going on. But, you know, like...
I don't know what you want me to say.
Preparing it is a lot of
Ypsilanti,
shock.
but that's not going to happen. Ypsilanti is a wonderful city with wonderful people.
It's a wonderful city, but there's a problem.
Every place has problems.
Right.
I don't
The
think
problem
I don't
which
think Ypsilanti is any different than any place else, but I'll let you go ahead. But you start attacking my home, we're going to have a
I'm
problem.
not trying to... All right. So,
I understand what you're saying, that there are issues, but I think those issues arise in our society in a lot of places. I don't think in a lot of ways that the city of Ypsilanti or the surrounding communities are any different.
the size of it makes it more pronounced. It's a small community. However, Judge, I'm just, you know, I don't want my client to be harmed, but I don't think that he is the big threat in Ipsy. He wants to continue to school. These 7 months have meant a lot to him. He has, in minutia, looked at discovery, and in fact would like to continue school as a paralegal. He wants to. I've known lawyers who have convictions that are, you know, so I think that this will help him. And so I don't think he should be branded for a lifetime. So I'm asking for a reasonable bond, whichever.
And if I look at and I think context is important, and people have pointed out some context to it, but if I look at the charges in and of themselves, I will reduce his bond, but his bond will be set at $100,000 cash surety. He must have a GPS location tracking tether prior to his release. I'll need a form on that one.
Thank you, Your Honor.
Thank you.
We'll let everybody take it. So,
Yeah.
all right. Thank you, Judge. Have a good day, everybody.
Thank you.
Sorry, did we get a circuit court pre-trial date?
Yeah, February 18th.
Thank you.
Yeah, we got one. All right. I got you out in time, Burnwell. You better get down to Kunky. I'm gonna call her and say, you're just like wandering around not doing anything. And that you said you can take your time getting down. I'm gonna tell you what I'm gonna say to you. Oh, she does? Oh, so you made me rush and you have permission to appear remotely in front of Judge Compton? You got it in the, oh. You were rushing me and yeah. I would have called Birdford. Okay. They ready with me? Court does call the case of the people of the state of Michigan versus Devontae Owens.
Andrew Childers, Franklin.
Yes, Your Honor. If you please design for Brandon Bird on behalf of Devontae Owens. Mr. Owens, can you please state your full name for the record? Devontae Owens.
Doing on this case.
Your Honor, it's my understanding that Mr. Owens will be waiving his right to an examination. He will be waiving on, in this time, we're talking about the amended information. Count 1, possession by prohibited person. Count 4, discharge from a vehicle causing death. And then count 6 and 7, which would be the 2 felony firearms charges corresponding to those.
And let me, I can find it. And to your understanding, Mr. Byrd, that's correct.
That's correct, Your Honor.
I just want to make sure we're all looking at the same thing. Six and 7. 6 is to 4. Seven is 2, 1. Okay.
New defendant, new waiver, same courtroom rhythm. Charges get trimmed, rights get waived, and the case moves straight to circuit court. Compared to earlier, this part feels smoother, almost procedural. No arguing, no speeches, just paperwork and consequences. It shows how fast court moves when there's no drama. Blink and your life just got pushed to the next level of the system.
All right. So, and then counts 2, 3, 5 would be dismissed.
Correct.
Got it. That's your understanding, Mr. Byrd?
That's my understanding, Your Honor.
Sir, you're going to waive your right to a preliminary examination on those charges?
Yes, sir.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes, sir.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution?
Yes, sir.
People also waive their rights?
Yes.
Preliminary examination having been waived, defendants bound over to circuit court on counts 1, 4, 6, and 7. Counts 2, 3, and 5 are dismissed. You waive presentation of the information and its reading.
Yeah, wait for my reading, stand mute, Your Honor.
Defendant have waive for reading standing mute. Court will enter a not guilty plea as to 1, 4, 6, and 7. Pretrial in this matter will be set for
February 18th at 1:30 with Judge Conlon.
February 18th, 2026, 1:30, Judge Conlon.
Thank you, Your Honor.
Thank you.
Honorable Court, have a great day.
All right, Bond. Thank you. What are we doing? Oh, that's it.
Mr. Bird, have a good one. Take care of yourself, man. Go see a doctor or something.
Oh, yeah.
It's always a pleasure.
All right.
Take care. Yep. Court does call the cases of the People versus David Childs, 2 cases.
Good afternoon, Your Honor. Alex Warren Green on behalf of Mr. Childs in both matters. State your name, Mr. Childs. David Childs. Thank you.
All right, what are we doing on these cases?
So in the case ending 2508, the people would ask that the court remand on the added count 2 domestic violence second offense.
Can you waive reading on that?
We do, Your Honor. We stand mute to the added charge.
So on that case, I will dismiss count 1. It's reigned on count 2, standing mute, and are not guilty plea as count 2. Pretrial in that matter will be set
February 23rd at
February 23rd, 2026, 9 a.m. before Judge Washington. And hold on a second. Bond in that matter will continue. All right. And on the other case.
Yes, Exhibit 250, people also seek remand on the added count 3 of domestic violence act offense.
Your Honor, the defense would move to dismiss the charged counts.
Counts 1 and 2. Counts 1 and 2 are dismissed. He waives reading on count 3.
We do, Your Honor, and stand mute.
And the court will enter a not guilty plea as to count 3. Pretrial in that matter will be set same time.
yes, February 23rd.
February 23rd, 2026, 9 a.m. before Judge Washington.
And Your Honor, may I be heard with respect?
Things get heavier again with domestic violence cases. Defense argues for bond reduction, talking sobriety, programs, family support, and a clean felony record. Prosecutor shuts that down with disturbing details, repeat violence, injuries, and prior convictions. The room tightens. This isn't theory anymore, it's risk. The judge weighs it, then denies bond without hesitation. When safety's on the line, sympathy doesn't carry much weight.
To bond in each case.
Go ahead.
Thank you, Your Honor. I spoke with Mr. Childs today, and he is asking this court to consider modifying his bond, which is currently set at $50,000 cash surety in each case, to a personal bond. Mr. Childs has no felony criminal history. He provided me with an address for his father's residence in Garden City. His father is a responsible member of the community with no criminal history himself. Mr. Childs has been in custody since his arrest at the end of December 28th, I believe, Your Honor. While he's been in custody, he's been focused on his sobriety. He has engaged with the critical thinking program, the cognitive behavioral therapy, and the Rising Strong substance abuse treatment. I believe he intends to continue that hard work once he does get out of custody, if that is today or at a later date. Mr. Childs is a small business owner. He owns a flooring company locally. So I believe an exclusion zone tether in addition to the original bond conditions is sufficient to assure the safety of the community and that he returns to court.
Response.
Your Honor, Alexander, on behalf of the people, at this time, we would be objecting to any modification of bond. These cases involve two separate incidents of domestic violence with the same victim. In the one case, he had pinned the victim to the ground because he had her neck and punched her in the head 10 times, and she had a black eye. I mean, that alone, I am concerned for her safety. He also has previous convictions for an operating impaired, domestic violence, and purchasing a firearm without a license, and another domestic violence from 2023. So at this point, I would have concerns for her safety as well as the community's asset bond would be set.
Anything else?
Nothing from the defense, Your Honor.
Motion for bond reduction is denied. Bond will continue in both matters. Thank you.
Thank you, Your Honor.
Thank you.
Sure what's happening.
Who's on it?
Mr. Hall. Mr. Warren Green.
Why are you guys staring at me like
I heard my name. Standing at attention.
Well,
And no remarks.
I have one case left. Do you know what you're doing on that yet? Or you need some time because you decided you wanted to be next door instead of here?
People extended a generous offer. And
So you're not answering my question. Go ahead, I'm listening.
Your Honor, I thought that we.
You know, I'm pretty good at being ignored. You know that? I am. I think that's the patient, good soul I am. That's what I'm thinking. Go ahead, you were saying.
I think the plan is a no contest plea, similarly to how I neither admitted nor denied the court's inquiry. But I think a moment to confirm that with my
You need to talk to your client.
I've spoken with him about the people's generous offer, and he indicated that he did want.
Might want to do that, but you think it covers, you need more time to converse with him. Is that what you're asking for, since you were spending all of your time next door?
If the court could accommodate.
Is that, sure, I'm out. Court's in recess.
Final minutes bring a strange mix, strict rulings in courtroom humor. Another case stalls, attorneys get called out, laughter breaks the tension, but the power balance is clear. The judge controls the room, always. The video ends reminding you that court isn't TV drama. It's fast decisions, real consequences, and no rewind button. If you liked this breakdown, hit like, subscribe to the channel, and we'll see you in the next video.